Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
You's a clown, that's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Hello, everyone. It is Pam Esquire, also known as your law intellect. Listen, I know you guys were in the first stream, and I don't know what happened. Me and Really B were trying to do our own technical savviness that didn't work out. It just froze. It was a trick of the enemy because they knew that we was gonna be clowning today on this live.
They must. I'm telling you, it was the spurts.
I said, "Do you think they flagged me?" What? I said, "Why can't I see anything? What is happening right now?"
Y'all were in there, but I didn't see it on my end, so I don't know.
I don't know, but we up and going now. So let everybody know that we are on. Make sure you hit that like button, subscribe if you haven't done so. Welcome to everybody that is in the chat. We started out. Oh, introduce yourself, Really B. Everybody knows you.
Hey, everybody. I'm Really B. How you doing?
One of your favorite YouTubers out here.
Okay, yes. One of your favorite YouTubers. Yes. What's up, Brother Dev?
Look, Dev came out of his sleep to come on live. And for that, we are eternally grateful.
Oh, Pam, can I say something real quick?
Go ahead.
I see St. James in the chat. St. James? Oh, St. James is so messy. He's so messy. Who I be over there laughing? Okay, I'm sorry. I be in your bushes, St. James. You messy, and you know you messy.
I told you what he do. He like, who, man? He'll sit up there and do a cooking show. Right.
He's
starving the brain.
Oh, this barbecue sauce is just right. That's what it is. I bet it is. He's talking about what I do. He's talking about what I do. No, he's talking what I do now.
He like, oh, let me go get me a drink. You know I gotta have a drink. He go open his calendar. He gets, you heard what they said over there on Fifth Avenue.
Ooh, I'm sorry, St. James. I mean that in the best way possible. But ooh.
All right, y'all. So back to the business at hand here. So for those of you, I did give some misinformation, so I have to correct myself. So yesterday, I did a live on the motion for summary judgment that was filed in Whitehead's Connecticut case. For those of you that don't know, he has a property in. Well, I know you was gonna say that. Shut up. He has a property in Connecticut, and it's a commercial property. It's an apartment building. We've seen the building on the thumbnail, parts of the building, and it was in foreclosure. And so we've been going over the whole foreclosure proceedings and the complaints and, all the documents like we do over here. Well, yesterday, I thought that today there was going to be a different hearing that was going to take place, but it was the actual summary judgment that we went over yesterday. Ironically, the hearing was today. So a lot of the members knew about it because I put the dates in there. So they knew about the hearing. So if you know, they probably got some numbers over there. They probably got some likes on that video. Because if you were a member, I usually try to update you if I know where you can
get that member tea. I gotta get that members only tea.
Because otherwise I don't put anything out here because I don't have time. Sometimes I'm just like, hey, I got this information and I put it in the membership. But there was a hearing today on the motion for summary judgment that was filed by the plaintiff. Now, again, we went over the documents yesterday, so you guys might want to refer to the video from last night where we went over Whitehead's objection. And it was very interesting. How many in the chat was over there and watched that hearing? Say aye. Say
aye.
Hey, Nene. Hey, VS Speaks. Hey, Simply Elegant. I see all of you guys in here. PN2 Ross. I see you over here. Chevelle said aye.
Aye.
How many was over there? They were a part of that number when them numbers started going up on that video. Rhodey said I tried. C. Wilson was in the house. Oh, Cheryl, you missed it.
Dang. It wasn't long. It ain't take long.
Yeah, if you didn't get in there on time, it started on time, and that judge was already like, what did I tell you guys yesterday? That typically the judge already knows what they're gonna do, but they just kind of entertain, like you have the right to an oral argument, so they entertain it, and that's pretty much what happened today. Whitehead did come. The judge acknowledged that he was there, but it is a motion for summary judgment. So, like I told you guys yesterday, you don't take testimony for that. That's not anything you have anything to say. Now, towards the end, I think he wished he had an opportunity to talk.
I can't listen. I mean, honest, I wish he had talked too. I ain't lied. I did. I wish the judge had let him say something.
Court started on time. Yes. You missed it, Don. How you? Oh, because you went live. I thought you were live. See, I thought you watched it. Because you said you wasn't gonna miss it yesterday. I know you went live, so maybe that's why you missed it. Lady D, how y'all miss it? You didn't set your timers like everybody else?
But I did. I set my timer for 11:27. So I can make up.
Jalecia said, yep, I remember that when she started because you can see she already made up her mind. Yeah. You knew in the beginning that she was like, okay, let's just move this docket along. I don't even know why they didn't just do this a month ago when they postponed it to today. Now it just didn't make sense to postpone it. So anyway, as you guys know, yes, there was a motion for summary judgment that was filed and what the plaintiff was asking, which is the mortgage company, the finance company rather, they were asking that the judge just grants all of their requests that are on their complaint. That was what they were asking. Whitehead responded and did an objection, and his argument was that it was a contract and only one signature was on there, which was his, and that because of that, the contract is not valid. There's no meeting of the minds, and that's that. Well, of course, the finance company responded, and they said, that ain't the law. You don't have to have, they don't have regular contract law. A promissory note, you need the person who's actually bound to that agreement. They're the only ones that need to sign it. So basically, both of them started out when they did their oral argument. To me, they summarized exactly what we talked about yesterday. That was in the document. I didn't personally hear them say any new information except on that response with Whitehead, where they tried to say that Connecticut law allows you to have one signature, but New York law doesn't allow you to have one signature. You have to have two, and these contracts were done in New York. That was the only thing that I saw that might have been different that wasn't in documents. But you go ahead, really, B. I don't want to be the talker here. I want you to tell me as a unsolicited juror, because you were out there.
Well, Yeah, that's what they did. The lawyer for the plaintiff. Well, who went first? The plaintiff went first, right?
Yeah, because it
So the
was their
plaintiff was
motion, so they're the
right.
ones that go first, and then they can have the last word as well because it's their motion.
So the plaintiff basically was like, "Look, I mean, I see what you done said, but just in case you didn't know, Connecticut law says that we don't have to have both signatures and like just go on and just give us this property. We just tied. We've been doing this. This man ain't paid a mortgage since June of 2022. It has been over a year and he has paid nothing. But he up here bragging about these Whitehead Estates. You ain't paid nothing. Okay, I'm sorry. I was going to go left.
Okay,
Let me stay here.
You done went off on the
I was
test.
going to go left.
I understand.
And then his attorney was talking. And his attorney started talking about all of this about, well, we don't even know who really was supposed to bring this action. On the paperwork, it say a man by the name of John Doe. And we've asked for information on John Doe, and we can't even find John Doe. Who is John Doe? We're trying to find the John Doe, and they didn't even provide us that information. And we don't even know, because as far as we're concerned, we don't know who owns this property. So how could they be filing this paperwork on a property that we don't even know who actually owns it? So then the plaintiff's lawyer came back and was like,
I think, just to stop you, I think they were arguing about who really gave the loan.
Right. Okay, who gave the loan? Okay, right, not the property loan. My bad. Loan.
That's okay. I know you passionate about this thing.
Well, I mean, because at the end of the day, child, what after I heard he ain't paid no mortgage in over a year, I was just like, I don't even understand how you bring your happy tail up in the court arguing anything. You ain't paid a mortgage in a year, sir. So then the plaintiff, this is the one that got me. What the plaintiff's attorney said, he said, you know what, you're right, I misspoke. I did say, because he was like, he talking about Connecticut law, but this took place in New York. And I feel like he thought he had him with that. It took place in New York. I was like, okay. So the plaintiff's attorney came back and was like, you're absolutely correct. I did misspeak. I said Connecticut. However, this is the law in 49 of the 50 states.
He did under the UCC.
Including New York. So your argument still is mute. I was like, I don't even understand how he's keeping a straight face right now.
So when the plaintiff came on, he said, well, Your Honor, most of these arguments have already been, raised. But I mean, the bottom line is he's defaulted on a loan and he's failed to pay. Lamor Whitehead has personally guaranteed the loan. And as far as I can see, he's looking. As far as I can see, I don't believe there's a dispute on those facts that he hasn't paid. He hasn't made a payment since June of 2022. And plaintiff will send a notice to accelerate this mortgage, to accelerate this note, and hasn't made any payment since, from my understanding. And we only require, I know they're talking about that it should be 2 signatures, but the law is very clear that you only require that the maker of the note sign it. So then there were also some special defenses that were raised. Whitehead, I guess, raised, of course, that it was some type of, well, no, I don't even think the plaintiff even addressed it. He just kind of said there were some special defenses raised. As you can see from the plain language, there's actually no supporting facts to back up any of those defenses. Then he said, Your Honor, I rest on my papers. Then the defendant comes on and he says, the defendant does dispute that FM is the holder of the notes and disputes that anyone from FM that they had anything to do with the notes. It has to be executed. I mean, that nobody from FM executed the document, so they didn't sign it. And said I agree with plaintiff that in Connecticut you only need 1 signer, but that's not what it is in New York. And the documents were executed in New York, which means they have to be signed by both parties. And then he said, I've just been trying, and we really can't even make a real connection between FM home loans. We found somewhat of a connection with FM Direct, but I believe that this is just a rush to judgment. There is an issue of material fact, and summary judgment just is not appropriate at this time. So yeah, that's pretty much it. That's what he said.
Yeah, because he was trying to say the summary judgment wasn't needed at that. Like he didn't feel like it was appropriate.
Yeah, he was saying it was rushed. So he's trying to see what happens is you cannot, if there's a question of fact, like say for instance, he really brought some separate document that showed that perhaps Pam Esquire, the law intellect, holds the note, and you had the documents with his signature or something like that, then perhaps that would be a question of fact as to who owns it. But you're just throwing up stuff of maybes, and then you say, well, if we have more discovery, perhaps discovery obviously is us trying to find evidence and doing depositions and interrogatories and requests to produce and subpoenas and all of that. So some people try to keep these summary judgments from winning by speculating almost, or making just conclusory statements, as we say, that, hey, if you give us enough time to go search in the garage and look at some boxes and go under the stairs and go to my old storage, then perhaps I could find something. That's, of course, I'm just exaggerating, but that's pretty much what you'll try to say to keep it open. Like, discovery is in its infancy, which is in its early stages, and that that's the point of litigation, is to go try to find more information. So they try to come up with any argument to keep this thing alive. Because of course, once the judge rules, it is a wrap. Like, there's nothing you can do. And in some cases, like, judges do like to consider these type of cases on the merit, or any case on the merit. But when it's a prima facie case and there's really no dispute, they ain't about to waste their time neither. So pretty much the court was like, then all of a sudden the court like stopped at some point and was like, I just would like the record to reflect that Whitehead has made himself, we've noticed him, that he's here, and was like, but he won't make no statements because it's no arguments. Just to let you know, ain't no statements about to be made because this ain't that type of a party.
I just want the record reflect that he's here, but there's no need for you to say anything.
Yeah, that's pretty much what they said. So then after the defense argued, then of course the plaintiff comes back and replied, I would like to point out that New York has similarly adopted the UCC, although, Connecticut law, even though I mistakenly said Connecticut law, but it's all good. Then he brings up the affidavit and was like, they're saying they don't see the affiliation between these people, and was like, well, our affidavit that we provided in the second paragraph obviously states that there's some type of affiliation. And he was like, there's no counter evidence, even assuming that you don't even want to believe the affidavit that this guy is a part of it. Y'all ain't produced nothing. There's no counter evidence as to whether FM Home Loans consented, just you saying it. You just making all these statements, but you really ain't have nothing. So you can't create a genuine issue of material fact. Like, you trying to create something kind of in your head that's not even there. You didn't even come with nothing to counter what we're saying. You're just coming with conclusory statements.
He had nothing.
The judge started, I already knew which way it was going really be when the judge started out and said, the court usually doesn't rule from the bench on these type unless its decision is abundantly clear.
I knew that then. I said, oh, it is abundantly clear that you about to.
Joe said it was funny. Then he cut off his camera. He did. He was like,
and he tried to come back. Did y'all see him try to come on at the end?
Yeah,
like,
I saw that.
He was trying. I said, oh. She said, good luck to everyone. Like, we ain't about to do this.
Yeah, pretty much. She already knew where it was going. So she essentially said that the plaintiff was correct on all that he said about the law, that it doesn't have to be signed by both parties. And the documents that were provided by the plaintiff show that the plaintiff originated. He was the originating lender. They were the originated lending, and that the plaintiff just provided all the support, and that the defendant basically has not produced anything to oppose what they're said. And then I guess the judge did try to go through those special defenses that were on there too. Was like, well, let me address the special defenses, because one of the defenses was that there was an insufficiency of service, the process of service issue.
Right.
So that came up, and the court was like, well, there was no motion to dismiss it based on insufficiency of service. And basically, if you try to do it now, it'd be untimely. So I'm not even going to entertain that. And you haven't provided any support for any of those claims in your special defenses. And yeah. And so he said, the motion for summary judgment as to liability is granted, is what she said. So of course they won their motion. For those of you that don't recall, you can go ahead and talk. I'm going to pull up what
I actually think we were on the same page, because I was going to say, Pam, can you give us the legal breakdown of what actually happened today? So the motion for summary judgment was granted, but what did we summarize? What that mean?
Okay, so when the complaint was filed by FM Home Loans, this is what they were asking for. So count one, they were asking for so when they did the motion for summary judgment, they were just asking that the court grant them judgment, what they're asking for in this complaint that I currently have on the screen. So that's what they were asking. Without any further court hearings as it pertains to this issue, we want the court to just grant it on all counts. That's what they were asking for in their motion. So if you go back, this is the actual complaint. I'll go to the top so you guys see. I'm showing y'all. The only thing redacted are the addresses. So this is the complaint. And so let's go down to the counts, because we don't need to go over the facts again. Obviously, I think the facts speak for themselves. Most people know what a foreclosure action is. So it has count one is foreclosure of the mortgage. The borrower is the record owner of the property, is now in possession of the property. Borrower is in default under the amended note, mortgage, and mortgage modification and loan documents by virtue of its failure to make timely payments. The loan documents obligate the borrower to pay the plaintiff the outstanding principal balance of 4.5. Ooh. And he was talking about Tasha. 4.5 million plus interest, fees, expenses, and other amounts that have occurred and continue to occur upon plaintiff's exercise of its right to accelerate. And the notice of default and acceleration, plaintiff elected and hereby elects to declare all obligations under the amended note immediately due and payable. The borrower has failed to pay this debt in full, including all principal, interest, late charges, and costs incurred by the plaintiff, including attorney's fees and expenses upon acceleration of the amended note. Plaintiff has fulfilled all conditions preceded to commencing the action. The following encumbrances upon the property sought to be foreclosed are our record or known to plaintiff and our prior and right to the mortgage and are not affected by the action. A, the city of Hartford may claim a statutory lien upon the property for unpaid real estate taxes due for October 1st, 2021, grand list. There are no other liens, encumbrances, or mortgages of record or known to plaintiff, which are subordinate to the interests of plaintiff. So they're saying they're first in priority. The borrower, Whitehead Estates, is the owner of the equity of redemption and possession of the property. The borrower's failure to make the regular monthly payments of interest due under the amended note and failure to pay the debt in full upon acceleration constitutes a breach. In light of default under the loan document, the plaintiff is entitled to foreclose its mortgage as modified by the mortgage modification on the property and to otherwise enforce its rights under the loan documents, including to collect rents and profits occurring from the property, to assume all rights, benefits, privileges of borrower, and to take possession and dispose of the property to satisfy the outstanding obligation in the principal amount of 4.5. Together with interest and other amounts due under the loan document, statutory interest and costs and expenses, including court costs and attorney fees. The plaintiff has caused a lis pending to be recorded. A lis pending is basically once you start litigation, you let you put kind of like a marking that says lis pending and let them know the court case in the register of deeds. So they did that. So count two, which is they asked to a summary judgment. They asked to win on all counts. So this is count two, breach of guarantee. Whitehead was the guarantee. The guarantee is the valid and enforceable contract. Borrower is in default of the amended note, mortgage, and mortgage modification and loan documents by virtue of its failure to make timely payments of interest and principal when due. The borrower has failed to pay this debt in full, including all principal, interest, late charges, and costs incurred by the plaintiff, including attorney fees and expenses. Under the guarantee, the guarantor is responsible for the borrower's payment obligations to plaintiff under the loan documents. Despite notice of said default by borrower, guarantor has failed to make payments when due under the amended note and loan documents. The guarantor's failure to make payment under the amended note and loan documents constitute a breach of the guarantee. There is now due and payable to the plaintiff the principal sum of $4.5 million plus interest, late fees, and for cost expenses of the action, including reasonable attorney fees and providing the loan. So this is what they were demanding. Okay, this is what they're demanding. Count 1, to foreclose of the mortgage securing the property. They want to take the property, sell it, get their money back. Deficiency judgment against the borrower. So if there's any extra money that say for instance they only sell it for $2 million and it's worth $4 million or whatever, they can still try to get the deficiency against the borrower. Attorney fee, disbursements and costs, the appointment of a receiver, that already happened in a whole nother situation that we talked about. And count 2, they want deficiency judgment against the guarantor. Attorney fees, disbursements, and costs, and such other further relief that the court deems equitable and just. Let's see who this guarantor is. So
we know who the guarantor is. Yeah.
Defendant Lamor Whitehead, aka Lamor Whitehead, hereinafter guarantor, is an individual.
Yeah. Listen. So essentially what just happened an hour or so ago was he lost the Connecticut property. That's final, right? It is officially in foreclosure, or that's what had happened.
Well, when the order is in, well, the judge, the reason why it's not an order yet, the judge basically was saying, sometimes judges will say the motion is granted for the reason stated on the record. So they have some process, it sounds like, where they put in there that you can review the transcript. Like they made sure that it was transcribed, everything that she said, so that that opinion basically coincides with the order. I didn't see an order filed as to now before I came on. Order may have been filed. I'll post it whenever the order comes down. But yeah, essentially, judge granted their motion for summary judgment for them to get what they want on all counts.
So they took the prop. There's no more Whitehead Estates in Connecticut, and he owes them $4.5 million plus late fees, taxes, and all of that. But they can sell it and they'll minus what they sell the building for from what.
Or maybe it's a surplus. Maybe they'll get money in their pocket, right? Ain't that how that go?
Yeah, that's how it goes.
I know.
That's how it go. You're right. That's how it go. So let me just make sure I'm clear on what is happening here. So he still owes the legal fees to Miss Jones because that was thrown out. I know there's another piece of that, but with Miss Jones though, that was thrown out directly with Miss Jones, and because of the slap statute, he owes those.
Yeah, you went to a whole nother case.
No, I'm just trying to understand the totality. I'm trying to understand the totality of what's going on with this man right now. And then today, he got y'all better go over there to Leaders of Tomorrow and put something in their collection plate because he need it. He need that. Y'all going over there.
You went to a whole nother case, Crystal. I ain't even updated on that one yet.
Oh, my bad. I'm just talking up. Listen, my bad. But we already talked about that the slap statute and the legal. We already talked about that.
Were you saying somebody said they feel sorry for the tenants, but they do have a receiver? That's actually hearing I thought was going to happen.
That's the hearing I want to hear. The contempt hearing.
So that hearing is still
get the
going on. I guess the motion for contempt, that's still going to happen. But that's what I thought was today. That's why I was like, oh, I done lied to the people like we was gonna know about the summary judgment in a couple of weeks. But
no, the renters don't get evicted. I mean, it's like when you live in an apartment building and they sell the building, you don't have. I mean, that has nothing to do with you. If they were gonna close the building, it's still a legal process that has to happen, but it shouldn't affect the tenant.
And if they sell it, they usually sell it to somebody where they're gonna sell all rents receiver. Like when they sell the building, they usually sell everything in it, so you end up having ready-made tenants and stuff in there. But the reason why I was saying it's not necessarily poor, there's a receiver that's in there whose job is to get the building up to par. And I'm assuming that this company has plenty of money to do whatever needs to be done to get it up to par. So
I bet you they could put up some iron fire escapes and not them old wooden ones.
we're not talking about the wood.
I mean, if we go listen, I don't want to go there because I know Pam said. Well, no, if y'all remember, we talked about that. I know Pam talked about it over here, and I talked about it on my channel. He was accused of being a whole slumlord. Them people was talking about that there was rodents and water.
It was in the article. Yeah, they had
an article that we covered. That was months ago though, but it was I know both of us talked about it. I know I did a video, you did a video. So I mean, there was a whole situation going on with the building to begin with. He was had to bring it up to fire code. You know he's gonna be mad he spent all that.
But see, that's kind of where I was going with it. Let's first of all, let's talk about this building.
In the rain, y'all. Slowing down the rain, but we working. We are working, y'all. Working. Stairs complete. Whitehead Estates, y'all. Coming all together.
Somebody said, why she say that I was lying about the court documents. Listen, that's why I asked who all was in the chat.
We were in there.
Want to say what they heard? Because it ain't just Pam now. We got court in session like today. So everybody was in there. We are the unsolicited jurors, and we was back there listening. So anybody that watched it, look, let me put this link in here. Anybody that watched it, I want y'all to tell these people if I was telling the truth or not on what this judge said.
I wonder if he paid them people that built them stairs. He just seemed like he don't pay nobody. I wonder if he paid them people.
But see, this is what I was saying, though, is that I said the same thing. What didn't make sense to me was if you were allegedly behind on payments, why would you even, it's just going backwards. Like, why would you come in and go pour money into a building that you might not have next year? That just didn't make sense to me.
Yeah, I'm sorry. I didn't mean to cut you off. Go ahead.
No, you're good. That's it.
No, I'm just saying I don't even understand his thought process. Like, I'm with you. I do not understand his thought process. Why would you, like, why are you not? I mean, I get it. You might not, you just probably just don't have the money, but the money you took to bring the stuff up to par, why didn't you pay the mortgage? Like, attempt to pay, do something.
Yeah, because once it seems like you do that, you may qualify for more money for the point of repair. Now, allegedly, there was a loan in New York that was taken out for some amount that was supposed to be secured by the building as well. That was supposed to be for repairs, if I recall correctly. I don't know. I'll be getting all these cases mixed up. But hey, Tracy, girl, did you watch it, honey?
I was in court today.
You was in court?
It was so entertaining.
Did you wear your good suits?
Of course I did. You got to come in your court's finest. I was ready. It would have been Sunday's best, but apparently this Sunday was sweatsuit Sunday. So, so I got to wear it to court today. It was great.
What were your thoughts, Mo? Could you hit mute for me?
So what I think is that he was planning to win one of these lawsuits to get some of the lawsuit money to put into the building at some point. You know how they be like, you rob Peter to pay Paul, you switch money from one place to the other. So I think one of these 17,000 lawsuits he had going on, suing somebody for something to try and get some millions from somewhere, he was thinking was going to settle so he can get a couple dollars so he could, keep on shysting something else. I think that's what the thought was. But nothing ever panned out. I really feel like he thought one of the lawsuits was going to settle and he would have a little money. and it just never happened.
Thank you, the prophet. How are you?
I'm doing good. I'm doing good. So basically, this is a classic example of a shoe booty grifter slash narcissist slash somebody who's hustling backwards and is basically got himself caught up in over his head.
Okay.
He's a grifter. He definitely is a hustler, allegedly, in my opinion.
This is
Well,
all our opinion now.
well, he tried to sue me.
He is very litigious now. Very
Okay.
Yes.
litigious.
Yes.
Can't lose control. Very litigious. So did you get a chance to watch the hearing?
I missed the hearing. I missed it because I was pretty much knocked out. So
I got you. Okay.
so I'm gonna have to look at the recap of it.
Well, they don't keep it up, so if you miss it, you miss it. That's why, and you can't record it, so that's why I've never streamed it. Like I follow to the T what they say.
Yeah. Right.
I ain't trying to lose my L's over Whitehead, nobody else.
Yeah, but I just wanted to drop my 2 cents in on it. Like, the thing what's bad about this whole scenario as it's playing out is like this dude just continues to keep talking himself into a hole. And it's like, he doesn't know how to just simply just shut up and be mindful of, what's projected and everything. And I mean, and real talk, like I just want this thing to be over.
Well, it's starting to wind down finally because I was really mad at myself that I even started. He's mad I talk about him. I'm even more mad that I talk about him because I feel I have to complete what I started. That's just my personality. So it's like I feel like I have to. That's why when they come with new stuff, I'm like, do not show me nothing new because I don't want to get nothing started that I have to finish. And
no, but to testify is that you were on point with everything, and people got to understand. And he knows this. Court documents are public. We can Google it. So you're just reading off stuff that's going on, and him attacking you and everything was just basically out of pocket. And it just shows the level of character that, what he's about and all. But, you definitely, talked about this thing from day one, like a few months ago. So it's like everything's accurate.
Thank you so much. Thank you.
Problem.
You hear that? See, I've been called worse by better too, so I don't even care.
So Pam, I have a question for you.
Thank you for coming on, Q the Prophet. I appreciate it.
So Pam, I have a question for you.
Sure. What is it?
So he has another hearing about this same building later on. What's going to happen with that? I mean, you lost it.
Well, it's not really, it doesn't have anything to do with the building per se. It's whether you should have some type of repercussions for the alleged behavior on not allowing the appointed receiver to come in and do their job. And you heard all them allegations that receiver said, of course he's going to get on and he's going to probably deny it, but that's testimony on whether he should be held in contempt. And they're asking for either civil or criminal contempt, if I recall correctly. So yeah, so that's going to be that's what I thought was the day. I was like, oh, it's going to be a hearing. They get to put people on, tell what happened, and it's going to be a credibility issue on what the judge. Yeah, what the judge believes. So
wait,
and this judge has been handling, because at first it was an older guy that was doing this case, and he was calling him bishop and everything. Like he was giving him, to me, at first he was giving him a lot of leeway and deference because he was the one that wouldn't even put a receiver on at first. Then I don't know what happened. Maybe he retired. I don't know what happened. But then this lady got on there and she ain't buying none of it. Like every time I'm on there, she's like, yeah, okay, that's a no. Like she just like, now the last time all this stuff was postponed because it was going to be a hearing and you were going to have people, but the subpoenas for the people to come were not within accordance of the rules. So you have to subpoena some people. You have to give them time. So if they're not prepared, they don't know what they got testified to. And it's time for the people that's being subpoenaed and also the attorneys, because how are you going to properly question them, if you don't have the time? So I see why they postpone that. But the summary judgment portion, I don't see why they even postpone that, honestly.
So he gonna come back to court for potential civil, or criminal contempt for a building that he now no longer owns. That is just karma and irony, and it is funny to me.
You know,
Because before, I mean, at least you own the building. So it was like, oh, kind of. But now you're coming back for something you don't even own. You have no claim or stake over. I appreciate the irony. I do. I feel like for as much as we all have had to endure, and I understand you and Really B are making y'all hundreds
did
of
y'all say he
thousands.
was on IG right now? Is he really be? I know you was looking.
Hold on. Is he on IG? Hold on, let me see.
Like he already dragging me.
No, I don't see him live.
Oh, okay. I thought somebody said he was on IG.
Look.
I want to see how this gonna spin because baby, I had witnesses. The Bible says you come with witnesses. I had witnesses today. I can't say what I didn't. What you hear, Tracy, when you was on there? You tell me what you heard.
Listen, I I was texting. I was like, wait, did she just say he lost the building? I was like, I think she just said that he losing. That sounded like he lost. Like, I can tell you, I don't know, but I know what it sounds like when you're losing. I know what losing sounds like, and that sounds like you lost because that sounds denied means lost. I know that word. Oh, that says denied. Okay, that means he lost that. Okay, approve
the
that.
court
I was
did
like,
a
oh,
motion for summary judgment.
judgment?
They asked to grant it in the court.
Yep. Look, that was granted. And when it came to his and was like, oh, your thing for follow up, they was like, that was denied. He didn't have I was like, oh, okay. They was like, he didn't have enough proof to back up the claims that he was making. I was like, sounds about right. He just talks with no proof to back it up. Sounds adequate. Sounds about right and in line. So to me, it sounded just about what it should have been. And I found it quite hilarious. And you know what? I do appreciate you saying you shouldn't record it. So I was like, because I'm quick to be like, screen record.
No,
So
some
I
people
remember you said
bypass
that
that where
before.
it
And was
says
like,
do
ooh,
not record. That's why, because it's on YouTube. And like here, some states like they stopped doing it, which is horrible to me because a lot of us do want to watch another state, so it stops that from happening. But that's why when it's on YouTube, literally they'll every now and then I think they may forget to take it down. So you'll see some court hearings that are still up. But for the most part, if you go to their channel now, what it says 0 videos. Well, we know they come on every day. So they only stream it and then they take it down. They don't keep it up there. So, and they'll tell you do not record. Now, you can request transcripts. You may be able to request a recording. You may request to the court that you record. You can as media or something, but no, otherwise without permission, you cannot record. And I don't know what the repercussions and consequences are, but I'm not trying to be the guinea pig to figure it out. So that's why I tell people like, do not record it. Do not stream it through your platform.
So I know you guys are both now very saddened that you are going to lose the hundreds and thousands that y'all was making off of y'all Whitehead, now that this case is now done, but y'all still have like $7 more
off that video last month. I talked about him $97. If y'all send me his cash app, he can have it.
Right
now, literally have it.
Now y'all may have like another 7 to 9 cases to deal with, but this one unfortunately is starting to wrap itself up. So the hundreds of thousands that you were making, you guys are gonna have to figure out something else to do. I wonder, because he was just at the hip hop concert with all those people. Like, how do you go from fight night, the hip hop concert, to losing in court on Monday? Like, that just seems real.
So because of Really B, no, I'm joking.
I agree.
Do y'all want to go over this Miss Jones stuff again?
Yes.
Since I got 500 of y'all over here. So
hey, listen, stop. Hold on. Before you get into that, because it's good. I'm telling y'all what she got to tell y'all is good.
Because really, I think she forget that I just talk to her and tell her stuff. Because she just talking. I'm like, ma'am.
No, I thought, listen. I didn't tell nothing. I didn't tell no secrets. Listen, before Pam get into that, because it's good. I'm telling y'all it's good.
Go ahead.
Can y'all go and hit that like button,
my documents.
Please hit that like button, please and thank you. It's free 99, y'all. It is free 99. All right, it's 500 people in the room. I think we need to have about 400 likes. That's all I'm saying. Appreciate y'all though. All right, Pam, go ahead, girl. Go ahead.
No, you go ahead. I gotta pull up these documents. No, you know that wasn't a part of my
Okay, so for those who don't know, let me refresh our memory. Miss Jones is a DJ in the New York area, I believe it is, and she spoke on Whitehead. We're not gonna get into all the details, but essentially, Whitehead said that she lied on him. Whitehead said that she called him a drug dealer. Whitehead said that she said if you go to his church, you're gonna get robbed and you're gonna get assaulted. Now, me personally, I felt like, well, 2 out of the 3 we can prove like people did get robbed at your church and people did get assaulted at your church. So I'm just saying. But what had happened was he sued her. He sued her for $50 million.
I have a question. Did people get robbed at his church, or did him and his wife get robbed at his church and the people just watched?
But they're people though. But what I'm saying is, but they are people. I know y'all. They are people. No, but that's my point. My point is, people did get robbed. It doesn't matter who. I'm saying people though. He's still a person.
I mean, sometimes.
Anyway. But my point is that people did get robbed. He is a person. So to say, oh, well, don't go to his church, people get robbed. Well, somebody did get robbed. You did. I'm just saying. So with that being said, he sued her.
First of all, we are not condoning nothing that anybody said that this man is saying is defamatory. So we, whether it's delusional or not, we ain't condoning none of that over here. So go ahead.
I ain't condoning it. I'm just saying, okay. So then, he sued her. First, he sued her for $50 million. Then he upped it to, I think, like $150 million. So it was crazy.
He did.
So, a decision was made in that case. Now, he tried to say Pam did a video on it, and he said Pam was lying.
He said that Pam was lying. He did.
He did. Well, he did a live on his.
He said I made it all up.
And he said Pam was lying. Pam was lying. And that case had been continued. It wasn't concluded. So Pam is bringing us an update based on the information that we have at this time. Is that accurate?
That is correct. Let me see if I can find the video when he was dragging your girl real quick about it.
He sure did. He did. He
said you dragged me for filth. I said, well, dang.
Hello.
Hey, Chef Don Don. How are you?
Hey, Don Don.
I'm a little upset because I had Donkey of the Day as my picture up here and it didn't come up here.
Oh.
Because, he sounds like he's a donkey of today.
He always a donkey of the day. He always the donkey of the day. But he'd probably be live before it's over with. Saying that we lying, that's not what happened. The judge didn't say that, child.
That's why I needed y'all to bear false witness. That's all I'm saying.
Well, no. Remember the last time what did he say? They had uploaded the documents wrong. That's why that's what happened. The court had put the documents in wrong, and that's what happened the last time. So now that we got the audio of the lady speaking it, I wonder what's gonna be the reasoning now. You can't say the documents
Miss Jones,
was wrong.
The one that had like one R&B song and just flopped, and then she was on, I think, the N Lover show back in the day, y'all, Hot 97. So now she's on 94.7 The Block. She called me a drug dealer. She said I'm hiding old drug money in the church. She said if you come to Bishop Whitehead's church, you might get beat up. She says so much stuff. So she has, I think her and her radio station, we have like $150 million lawsuit on her. Yeah, that Miss Jones. Yeah. No, it was not dismissed. So let me just tell y'all what happened. Yeah. Baldhead Pam said it was dismissed. So what happened was, she ain't gonna tell you everything, but what happened was the courts inaccurately
y'all put your bald-headed
sent out
emojis up.
A paper saying that it was dismissed because it was in their error. but they corrected it because they didn't see the opposition for whatever reason. But it was a mistake, an honest mistake by the courts. They didn't see the opposition, and they had prematurely, since there wasn't an opposition, because the courts asked for us to amend something, and because we already filed the opposition, but they asked for an amendment, and we put our amendment in. They must have overlooked it and thought we did not oppose, so they had put in a dismissal, but they immediately fixed it, and the courts emailed my attorney and let them know that it was their mistake, and they vacated that order, and the proceedings are going forward. But Bullhead Pam is not going to say that.
You make me so sick. I swear you do.
Okay, so that's what he said. That's what he said. That's what he said about your girl. It's all good though. But anyways, so let me tell you what the real skinny is. So you guys know that I did commentary before, and I think Don did as well, where we went over the order of which it showed that there was a dismissal. So now we're going to have to back up for you guys to understand there has been a lot of action that occurred in this case since that time. And I said I don't have a problem going back over it if some changes, occur. So this was the first order where it had decision in order of dismissal, right? And it was dismissing Jones and also was it? I can't remember the other name. But anyway, the footnote is very important. So it has in motion sequence 001, defendants moved to dismiss the complaint. Defendants thereafter withdrew the motion to dismiss on the basis that plaintiff filed an amended complaint. The county clerk rejected plaintiff's amended complaint purporting to remove defendant Paramount Global, the block, from the caption and adding Odyssey, New York, to the caption on the basis that plaintiff failed to obtain leave pursuant to CPO R1003. On July 10th, the plaintiff filed the corrected amended complaint. On July 13th, this court filed a decision in order resolving defendant's motion based on the complaint as the operative pleading for the purpose of the motion. The court now revisits defendant's motion to dismiss and resolves the motion based on the corrected amended complaint. So what happened was when I went over the first motion, we read the footnote, and that footnote basically said they didn't file their amendment right, so we're not even going to deal with their amended complaint where he's asking for the 200 million or whatever crazy number he's asking for, and he changed who he was suing. And he said, but we're going to rely on the first complaint. So according to this, and you can see it on the actual docket, what happened is if you go up here, and this is where Whitehead, this was truthful what he said, that there was an error in the court when it came to that. So let me see where the amendment is. So you'll see that it said corrected, and I showed you guys on here. This is the actual docket. Anybody can look it up. It's public record. It ain't just there for Pam. It's public record for anybody to look it up. There's been a lot going on in this file, as you see. But let me go to when he did the corrected. I'm gonna pass it. No, because it was after they filed. So let me backtrack just so you guys aren't confused. A complaint was filed in this case. Let's start from the beginning. Complaint was filed where Whitehead sued Miss Jones. In response, Miss Jones' attorney and whatever entity they sued at the time as well filed a motion to dismiss, similar to what we're just going through with this Connecticut property. They filed a motion to dismiss. You see that? Y'all see the notice of the motion? That was December 12th. They filed their memo, their affidavits, all their exhibits, which actually shows what she said. She's saying she ain't say what they said she said. We have all of that. Okay. They also did a proposed order, all of that good stuff. Consent to change attorney's audit. So right here on the 36th entry, you have a complaint. So instead of responding to the plaintiff's motion to dismiss the case, Whitehead's attorney amended the complaint. And this is when they beefed it up. We went over that and they added specific quotes. And they also, at the end of it, they asked for more money. That's what he was talking about. As you see over to the right, it has July 10th, 2023 is when they corrected it. Okay, so the amended, so it was a correction. There was an issue with the caption. So what the court did was when they did their order, they did it based on him not correcting whatever procedural. It was just like something he did with the caption or didn't get permission. Something wasn't right procedurally is what he needed to amend. So the court rejected it when he amended this. So when the court did their order, basically granting the motion for summary judgment for Ms. Jones, they did that order based off the first complaint because they said the second one wasn't right. So it crossed paths. So what the judge did now is they was like, oh, okay, well, since now we'll revisit it, but they submitted a whole nother order. And when they submitted this order, they basically did the same thing. They dismissed it. But they said in the first one that even if they did it according to the amended complaint, they still would have dismissed it anyway. But so they did revisit it. So a whole nother order was again done. We went through this already, so I ain't gonna go through that again on what they said, basically based on the anti-SLAPP. So on this motion, this order, which was July 24th, the court ordered that the branch of defendant's motion to dismiss the complaint is granted and that the amended complaint is dismissed. Instead of the original, now we just gonna dismiss the amended one. And then further ordered that the branch of the defendant's motion for attorney's fee is granted. So we still gonna grant your attorney fees. And it is further ordered that the matter be referred to a special referee who shall hear and determine the amount of attorney fees. So that's what it was. So then I went back to the court, and the court was closed, but now it has active and restored. So I'm like, okay, well, why is this joint active now? So what happened is, according to, and it just sounds like a bunch of clerical errors, I guess. But it looks like the court not clarifying the order. Was it the entry? Let me see. Let me make sure I'm pulling up the same. Given to the court. Nope, that's not the one. They just like kept on with this order over and over again. Notice of county clerk. I gotta find it, y'all. So that's the same thing. They had it in here so many times. But there was another decision that came down where the court basically reopened it because they were saying the case was not against the motion for summary disposition or summary judgment was only against Miss Jones and Odyssey, and it was not against Paramount. So they were saying it was going to be reopened as to Paramount, if that made sense. Y'all get what I'm saying over here on this panel?
I get it.
So let me see. I'm trying to find the child. They just got the same stuff over and over again. Order proposed. Did they take it out? Clarifying the order. Okay, here it goes. So then on July, whatever the date is, they clarified and they said this matter was inadvertently marked as disposed pursuant to this court's July 21st decision and order as only co-defendants Tarsha Nicole Jones and Odyssey New York LLC moved to dismiss the complaint, the complaint remains active as against the additional parties remaining as action, to wit, Paramount Global, DBA. So they're saying like the motion to dismiss was only filed on behalf of Tarsha and Odyssey. It was never filed against Paramount. But what was confusing me, guys, was the fact that the footnote said that that's what he did, was he removed Paramount in order to add Odyssey. So I'm like, is Paramount even in this case? So that's why I was confused at the way. So in theory, it's active, but it's not against Tarsha because it was dismissed against her, and against Odyssey, it was dismissed against her. As you see, there's been some movement on this motion or this hearing. Now, something else was just filed by Ponder on August 8th, where he basically said, please take notice that pursuant to the provisions of New York CPLR Section 3217, the above entitled action is hereby voluntarily discontinued as against defendant Paramount. Only. They was the only ones still in there. So it looks like Ponder has discontinued his case against them. So there's nothing left if they're discontinued. Or am I
so then you didn't, child, bye. But he did all that. He did all that to say you was wrong just for you to be right. Child, bye.
So I have a question. Is that because in New York with anti-SLAPP, you kind of basically are forced to pay the legal fees if they toss yours out, right? So is it basically like, well, I know they're going to toss us out too, so I basically don't want to have to pay legal fees again if I just pull it back myself?
It may be. It would be smart if that's the reason, because, but for me, when I was looking at the other documents, if you guys, when I read the footnote, it said, right, that Paramount, where is that document at, where the order, where they were saying that Paramount, is this the last one? They said the county clerk rejected plaintiff's amended complaint, which purported to remove defendant Paramount Global. And it has all of them, and add Odyssey to this caption on the basis that plaintiff failed to obtain leave. On July 10th, the plaintiff filed the corrected amended complaint. This court filed the decision in order resolving it before. So in my mind, I thought that they had already tried to remove Paramount anyway. So I'm like, why would it be open against them and not dismiss? Like, wasn't they not a part of the amended complaint anyway? But maybe not. Maybe I'm missing something. But nevertheless, Brian Ponder has filed something to discontinue against them. But as you guys can see, there is whatever documents that needed to be filled out to go forward with the attorney fees has pretty much happened as well. There it goes. Whitehead hearing and determining amount of attorney fees to be awarded. In order that this matter may be assigned official, so they filled out whatever needed to be filled out so that they can go figure out what these attorney fees is looking like. So I don't know what you're talking about, Whitehead, at this point. I mean,
he don't either.
I done showed the whole docket, so I ain't make it up. Whatever's in there is in there. He basically tried to say to his attorney, for some reason, they didn't see the opposition. No, they actually, according to that, there was a rejection of your amended complaint. Not that there was an issue with you not seeing the opposition. I don't see that in there. Now, they've already filled out all the documentation to go for the hearing for the attorney fees. So hopefully this answers y'all question. So y'all ain't got to ask me, because really B want to bring stuff up that we were talking about offline.
Wait, what? Don't blame Really B.
I'm joking.
See how she do?
You know I'm just playing. If anybody wants to, thank you so much for the memberships. I wasn't over. I was over
welcome to all the new members.
Thank you. Make sure you hit the like. If you want to become a member, it's in the description. There's a link in the description. I know somebody.
Oh, he posted such a cute little reel.
You said you know you altered that docket with AI. You know what?
Oh, he posted a cute little reel with Lil Durk. All my life, people been trying to keep me down.
That's what he
did. All white. He ready.
All my life.
Oh, y'all know it's
he about to.
Hold on. Let me go over there. What did he say?
All my life.
Hold on. Yeah. Look, you know how he like to. Oh, wait a minute. Shoot. I'm sorry. I wanted to get your music. And he driving in the car. He driving in the car like he ain't got a care in the world, child.
He's
And
sick
he's
of me.
smiling. You know he doing that little smile thing.
Oh, there go that fake smile. Like, I'm gonna be all right.
That unhinged live is about to be epic. I need y'all to understand. My troll page is about to be on fire. I might get my third page blocked, y'all. I might get my third one blocked.
Now, because y'all know she stay getting blocked over there.
Well, I just pulled up the whole docket, so I don't know what the heck y'all want me to do about it. I just listen. I showed y'all you can go look for yourself. Not saying I made it up. I'm a bad mamma jamma. If I'm over here making up dockets and documents being filed. So it still hasn't opened as active, but I don't know who the heck is. Maybe it's just still active at this point because they still got to do the fee situation. That's all I got, y'all. Anything else? I said I would go through everything. I'm like, whatever you file, I'll come back and say what you right about, what you wrong about, what any, in between. Don't matter to me. I don't have a dog. I think people get this twisted, and I had to really let people know I don't hate Whitehead. It ain't that deep for me. He's like, I do cases for a living, so I don't get emotionally attacked. Sometimes you do because you're personal clients. But for the most part, you don't really get emotionally connected like that. So it's really just a case. But people, because it's personal to a lot of other people, they thought they could utilize me as the person that'll be out here windmilling for them. But I'm not. If you ain't got the kahunas to stand up for yourself on anything you're alleging he did, Pam ain't doing it. I'm going over the document. That's why when people try to, they want to come on and they want to go off or whatever, you're not doing that on my page because it just ain't that deep. Like, it's just not that deep for me. It really is like something we chose to follow because he wanted to be in the public light when it came to this whole, this whole robbery situation. That's it.
And I agree. And, my little 2 cents on it is, ditto. But, Pam is going to give y'all the legal. If, me and Don and, some other people that break it down, we're not attorneys, so we give you a little bit more of the street. But when you coming through Pam is just going to read y'all the legal document. She's going to break down what the legal, what the legal side of it is. She's not going to give no advice because, people be watching. So
they waiting on it. They like, yeah.
Right. They waiting on Pam's legal advice. No, ma'am, you got to pay for that. The coins. Got to give her the coins for that. But so I don't even understand where he be coming from when he just like, nah, she just telling you what she wants y'all to know. No, literally, she is pulling up the docket and reading. Y'all hear her reading it word for word. Word for word, she be reading it.
Boring y'all half the time. And I still be like, no, we ain't trying to alter it. I might summarize it, after a while, like summarize it, like, yeah, I got lost in my own reading. So let me go ahead and summarize it for y'all.
And the reality is, you're right. The reality is, you're right when you say, not you got blocked because you kept pointing out spelling errors. I cannot, I cannot. But if he would just shut up, this would have went away and nobody really would be paying him no attention. But he can't stop talking. It's the narcissist in him that thank you, Brother Dave. He can't stop talking. So, I mean, if you're going to keep giving me content, I'm going to keep making these hundreds of thousands of dollars.
Child, and I need you to share because I'm missing a couple of zeros.
You know what I'm saying? I would keep making these. Listen, with all of the content I do on my channel, I ain't making hundreds of thousands of dollars. I promise you that.
I definitely make more money on other people's videos than him. I definitely do. And it makes me too because I made it clear to a lot of people, like, your story is interesting. I've had so many. I told really big. She knows some of the people that done talk to me. Like, I'm close that alleges they are close to him. I'm not doing that. Like, that's not what my platform is about. And then at the end of the day, he come for me, and then I be sitting up here like, there go my Cash App. I don't want to spend my nest egg on trying to do this and that. Nobody gonna be there for that. I'll be the only one that gotta defend that type of stuff. So I'm very cognizant with what I do. I'm not gonna be used as nobody bulletproof vest. It's just not happening. I'm just way too smart for that. So
that's why Sharice
happening. That's why they all caught up.
Right. That's right, Sharice. You're right. We did get a raise. He said we making millions now. We did get a raise, Pam. We making millions now, child.
Now, if I could make millions and he has some type of way that he knows I can make millions, then we could talk. Listen, I will change this mug to the Whitehead Estates.
I told y'all that a long time ago. If I was making hundreds of thousands of dollars off of Whitehead, it would be Whitehead 24/7 over there. I'd have moved to New York just so I could follow him around. It'd be Whitehead 24/7.
Listen, now he would be right. He would be right. Because if I was making that type of money, I would wake up talking about Whitehead. I would go to sleep talking. Because I wouldn't have no reason to do anything else. If I'm making millions of dollars off of you, listen, I will put in my P number, my bar number, and be in retirement status. Because I'm talking about Whitehead. I'm making my money.
I would have retired by now. I wouldn't be getting ready to go back. I wouldn't be ready to go back to the schoolhouse next week, child.
You know what, Pam? Can I ask you a question?
Of course.
As an attorney, is there like, you know how there's like, oh, there's, civil, there's criminal. Is there attorneys who their sole thing is like, I don't care about my reputation. I file stuff just to make money. Like, is that like a thing in the legal community? Like, is that like a thing?
None of the people I know.
But is that like a thing? You know how like in everything, like there's like this type of thing. Like, is that a thing? Like
I haven't seen it. Of course, there are some lawsuits we'll say that are frivolous and but usually they have some type of teeth to it. I've never had any just blatant frivolous lawsuits they say, like, even when I did personal injury, my friends would be like, you're not a good personal injury. Because I'd be like, child, you're not injured. You need to go someplace else. Like, I was one of them. Like, your little strain you got in your arm is about to heal in 2 days. You're not about to have me spend all this money up front and then I end up losing on a summary judgment or something. Like, that's how I am. Everybody's not like that. I know some people some people do cost benefit analysis and they just want to get something. Oftentimes you can file stuff and people are like, it's cheaper for me to pay you $10,000 and to pay my lawyer $100,000. So they'll go ahead and settle and give you the little $10,000 for a cost benefit analysis. Some attorneys hope for that. They hope that that's going to happen. But for me, I don't even take cases that I think are good. Everything I take, I believe in. Now, there's been times that I've stood in for people or people got sick or they asked me to take over cases that I probably wouldn't have originally taken. But for the most part that I've taken over. But for the most part, yeah, I don't do that. I haven't seen it because there's consequences. I know here, like when you affix your name to any document, you're basically saying that whatever you have is valid in facts and law. So you're a fine to that. So we have court rules that you can get hit with attorney fees and sanctions because you file it. So I've always been cognizant of that. Now that's the thing with this anti-SLAPP, specifically in New York. They have it where oftentimes attorney fees are discretionary for the judge. You can think I should be getting attorney fees for this because even you, judge, said it was frivolous. But a lot of times judges don't give them because they feel bad. They don't be wanting to like hit another attorney or their client with attorney fees. But under the anti-SLAPP, it's not an option. It has shall. Anything with shall. If it had may award attorney fees, then that's discretionary for the court. But when it says shall, you need to know before you file these lawsuits that you pretty much know that you have a good case because you will be hit with it's not even an option. It's a shall. They remind the court what that little caveat says on the anti-SLAPP statute. You're going to go to a hearing, and that can be expensive, especially when you're hitting big companies that they got bottomless pits and money. So they're going to use the best of the best. Like you research their attorneys, they got like the biggest lawsuit the biggest law firm in the United States. They're going to pick the biggest defamation lawsuit in the country. And they got 25 offices around the country and in the other countries. Those are the ones they're going to pick because they're corporate. And corporate people, they need lawyers even in other countries. So you're going to pay for that.
Child. Well, I tell y'all what. Tracy is my producer, showrunner. So we will be on the lookout for when he go live, because baby, he gonna go live.
I've been refreshing Instagram every 2 minutes. Like, listen, listen. I got Instagram up on my on one of my screens on my work computer. I'm like, baby, I will not miss this one because if nothing else, this will be one of those classic unhinged ones where I get to hear about his Job season.
Wait a minute, did y'all hold on? All right, I know we're gonna do this on Pam channel, so I'm gonna say this and I'm gonna be done.
Okay.
But did y'all see that Bible he pulled? I just happened to click it on Sunday. Did y'all see that Bible he pulled out Sunday? Baby, I ain't lying. I'm not exaggerating. That Bible was this big, and it had paper. I promise you, he must have had
I've seen his Bible before. He said that's what he had. I think when he was in prison, maybe I think is when he had that. So,
and he just steadily highlighting. He always highlighting. It can't be nothing left to highlight in that Bible, because he is always highlighting something. I ain't never in my life seen it.
I refuse to believe that those are actual Bible pages in there. I refuse to believe. I was like, I need to see the inside of the book. I was like, I could recover anything. I'm sorry. I can recover anything. I was like, I want to see what's on the inside because there's just no way. There's just no way. I'm sorry. But you know what? To each his own. I just let him have it. I mean, I shouldn't be crushing his dreams because I don't want nobody to quash mine. You're gonna be a fabulous prison bishop, sir.
He said that Bible was passed down from his ancestors. See, I'm not gonna say nothing. I'm gonna let that go. I'm gonna leave it there. I'm gonna leave. That's what somebody in the chat said. I'm gonna leave it there.
He's gonna be a fabulous prison bishop. Let him have it.
The bad part though is, and I've said it before, and you know, Whitehead might say I'm like I don't know, what do you call me? Some type of, basically I was an unaccomplished lawyer, but he said a
failed lawyer. I think he said you were a failed lawyer. But he also said you wasn't married. So I mean, and he said you was bald head.
Oh yeah, but whatever. But I will say, like, I don't think he's dumb. That's the thing. I always don't think he's dumb. I think he is. He does have, and he really has. He has the mind to be the multimillionaire that he wants to be. That's the sad part about a lot of this stuff. It's like, dude, all you had to do was go to the right or chill out for a minute, or you know what I'm saying? And you got caught up in all of this. So that's the bad part about it. But you know, I can see the whole picture. I know some of these people just hate his whole guts. Believe it or not.
I'm gonna be honest with you, and this is my opinion. I truly believe this. This is my opinion, y'all. I swear it is. And I'm being serious when I say this, and I'm gonna say it nicely because I'm serious. I do not think the intention when he started all of this, and y'all can figure out what I mean when I say all of this. I do not think his intention was to not do right. I think he wanted to flex. I think his intention was to have these apartment buildings and to have this property. He wanted to flex. I think some things ain't go the way they were supposed to go.
But with that apartment, it's not like those apartments are not a good source of income. They came with tenants.
Absolutely. That's what I'm saying.
That's why I'm like,
I don't think his intention was for this to. Now again, I'm not gonna publicly get into what I think happened or how I think it was there, because I ain't doing all that. Ain't nobody gonna sue me. But I just do not think his intention was for it to go this way. Now again, I ain't gonna get into what happened, what didn't happen, but I honestly don't. And when I say he's not dumb, you know, there's a difference between there's certain types of intelligences. He's not stupid. Now, are there other areas in which he does not exercise emotional intelligence? Sure. Are there areas where he may not have PhD level of intelligence? Absolutely. But he's not stupid. And I think a lot of times we underestimate people because we see them acting buffoonish or doing buffoonery, and we equate that with them being stupid, and they're not. Perfect example, that argument that they tried to make today with the summary judgment, they knew that argument was some bull hockey. They knew it. Like, you gonna sit there and say that basically you should nullify this because I didn't read my contract. Everybody knows that that's not, like, ignorance of the law is not a defense. Like, everybody know you can't say, oh, well, I've read this document, and yes, I have intelligence, but they scammed me because I didn't. He knew that was but he was just grasping at straws. You get the right judge on the right day. Hey, anything can happen. You know what I'm saying?
But you can't have it both ways either. It's like you can't be an expert on one hand and then conveniently be a non-expert when you feel like it'll help.
Exactly.
Pick a struggle. That's all I'm saying.
Right. You can't be teaching real estate classes, but then say you got swindled in a real estate deal. That's all I'm saying.
It's just pick a struggle. I mean, they didn't bring that up. I'd have brought it up if I was the plaintiff. So I'd have been like, oh, that's very interesting that he's saying that he's non-knowledgeable. You know, that'd have been something I brought up, but I might know a little bit more information because I've been following. But yeah, that was definitely something that could have been a source of income there. That's why I'm just like, dang, like
I told you, I think he thought one of these multi-million-dollar lawsuits probably would have settled for some money, and it would have given some more money to fund some other things, to move some other things around, potentially, possibly, maybe, allegedly, all those good maybe words that, like to come up. But maybe those, would have fund some more money to give cushion to the lifestyle, but then also give cushion to get the properties up to code. So I do think the thought process was, oh, wait, the people are on me. I need to get these properties up or up to code, or I can't get nothing. Hold on. I need money now to get this up. Because I'm almost for sure it was either you or Really B who had did the thing, and he had took out a loan to get work done like a couple years before that for the property. So it's not like he hadn't taken out money like a year before that to work on the property. So I don't know what happened with that money, but whatever. But so, I do think that there was a thought process there at some point, but I want to live above my means kicked in, and the money went somewhere else, and he just thought he would get more money, and it never happened. And then I also think that, because he was thinking that, during the panini, people got to stop paying and things happened and everything kind of shut down for a while and everything got frozen. So then when things started back, you could get these write-offs and they will give you these extensions that you can do these other things to buy yourself more time, that he thought he had more grace or more time than he really had available, and they was just done with his foolishness. People get tired, which is all completely fine. I just simply know that this is all going to lead to a very interesting IG live that I'm going to be very interested in watching, because it is going to be entertaining.
And y'all don't be in the chat talking about, but Pam said, y'all know I'm his trigger word.
Right, y'all know y'all be giving Pam in trouble.
Doing that on purpose.
I apologize.
About yourselves. Y'all supposed to be like, but I saw the hearing, and the hearing said, that's what I want y'all to say, okay?
No. Oh, no, I don't do that. Listen, under my troll page, the way I tell you I get this man going, oh, do I ever.
Tracy be in there trolling him, and I'm like, Tracy.
Listen, hey, I go from one extreme to the other. It's either I'm either a pick me, and I'm like, what do you mean? Yes, bitch. Yes. Keep talking.
No,
tell me about
the last time you got blocked, Tracy, was hilarious because the man said, look it up. Look it up. When he was talking about his prosecutor went to jail. Remember, he was trying to say his
put it in the chat.
Look it up. Look it up. Pam, Tracy in the chat to myself. I looked it up. That wasn't your prosecutor. Your prosecutor was boom, boom, boom. And she put the case number. Oh my God, she dropped the case number, everything in the chat. I said, Tracy, you knew you was gonna get blocked.
Well, that's the other way.
You was gonna get blocked.
So I have two listen, I troll on both ends. So I troll on either the pick me, or I troll on either the I'm about to get you agitated. It depending on how I'm feeling is depending on the way I go. Cause I be trying. I be like, listen, what you gonna respond one way or the other? So I be the person in the chat.
And
I
I
be trying to get
watch
information.
them. I just get a bunch of, and then y'all, if you're gonna want me to see it, because it probably won't be till the next day I see your DMs, at least screen recording. Y'all be sending me links to his lives that he don't save. I be like, what y'all got? Video removed. Thank y'all so much for 5,000 video removes in my DMs. I appreciate that.
Right.
Don't worry. Don't worry. I saved it.
Save them. Y'all
Don't worry.
I
I saved it.
gotta wait for Really B to tell me that Tracy got it. That's how I get them all the
Because
time.
I'm the person in the page house. No, Pam said that's your case.
No, y'all seen the document? It ain't Pam's. I pulled up the whole online site.
Now,
And Pam ain't said nothing. Y'all seen it yourselves. That's what I need y'all to say.
So on this IG live, when y'all see, Pam showed me the whole feed.
Right,
I see all 37 entries. Y'all just know that that's one of my troll pages. I'm like, we seen all the entries. Y'all just know that's me.
You gotta put Pam in there. Y'all just can't leave me alone. You know, I am like the thorn in his side, like Paul.
You really
like, I just wish she would go somewhere. Why she ain't got nothing to do? Don't she got a husband? Don't she got kids? Why she on my head?
Child. Well, we'll keep y'all updated, child. Like I said,
I need them to
break down.
I need y'all to practice the court said. This is what I need y'all to practice. And y'all repeat after me in the chat. The court said.
Thank you, Ray.
Not Pam said, because Pam ain't said nothing. Pam just pulling up the documents and I let you guys see it, but y'all still. Then the first thing I'ma hear, y'all already know this is what I'ma hear as soon as it's on there.
Remember Miss Jones, y'all? The one that had like one R&B song and just flopped. And then she was on, I think, the Ed Lover show back in the day, y'all, Hot 97. So now she's on 94.7, The Block. She called me a drug dealer. She said, I'm hiding old drug money in the church. She said, if you come to Bishop Whitehead's church, you might get beat up. She said so much stuff. So she has, I think her and her radio station, we have like $150 million lawsuit on her. Yeah, that Miss Jones. Yeah. No, it was not dismissed. So let me just tell y'all what happened. Yeah. Baldhead Pam said it was dismissed. So what happened was she
Look, I put the document of Bishop. I put the Bishop, Apostle, Chief Apostle of Leaders of Tomorrow.
Not Chief Apostle.
International Ministry. Chief Apostle.
Ooh, I
put what the court said. That's it. That's all.
Listen, now they're gonna say, I can't wait till he go live now, because now everybody gonna be in the chat saying the court said. Y'all.
Oh,
looking at them, they already in the comments talking about Pam Reed. So let's see what I'm saying. Y'all can't even say it. Y'all can't not say my name for the life of y'all. Dang.
So I need y'all to practice. Like this, how you doing here on his live?
Yeah, everybody in the chat.
Wait,
the court
wait a minute.
said.
Right. That's what he doing his live. Everybody in the chat say the court said. The court said. The court. And everybody in the chat to say the court said.
Wait.
The seed for today is the court said. Hashtag the court said. That's the seed for today. Wait, y'all know it triggered. But Pam read the documents and she put them up. It'd be like, dang, why you can't just say I saw the documents? Why you gotta attach my name to it? Dang. Y'all know, be having my husband in here like while I be laughing because I'm like, child, whatever. I don't even know to get under his skin like that. It's people with bigger platforms that talk about him way, you know.
Oh, well, tell Dev I apologize, because that probably be me. Like, I apologize. That'd be me.
We appreciate you admitting it, Tracy.
That'd be me. That definitely be me, because I promise you, I'll be getting his pressure up so he talk. Listen, talk. Just keep talking. I just need you to keep talking.
Child,
just keep talking. Just keep telling on yourself.
Leaders of tomorrow, child. He be ready to drive the leaders of tomorrow.
Just keep telling on yourself. Need to.
The court said. Everyone repeat after
It
me.
is, the court said.
The court said.
Listen, y'all. Let me ask y'all a question. I just want to ask y'all a question. I'm gonna ask y'all a question. Would y'all want?
See, you know, Mel Lee talking about, can we say Pam said the court said?
Y'all, when his criminal case started, at this point, if he even had a daggone criminal case, child. Listen, do y'all want us to go to the case? Y'all want us to go to court?
Y'all want to go down to the court front and center? Y'all better start saving up y'all.
I'm about to say, because I might have to take off work for a couple of days. I don't know. Y'all tell me what y'all think. Y'all tell me what y'all think.
I'm just driving down to my mom's house. I could go. So
wait a minute, that Deb can't drive to a non-location. Oh, y'all are wrong.
I'm not doing this with y'all. All right, that's my cue before I get some paperwork in my mailbox. Okay,
it's time to go.
All right, you guys. Thank you so much for coming in and hanging with me. We had a really, really good time. We've been on for an hour and a half. Make sure you hit the like button, subscribe if you haven't done so already. Thank you to my panel, Really B and Tracy. Thank you so much for coming on. I don't have any type of sound effects. That's all.
Oh, Miss Bonner said she's gonna put something on it for us, Pam.
All right, yeah, I need y'all to say that Starbucks money, because honey, that New York is not cheap. New York and California,
New York is not cheap
for these doggone cases.
At least I can drive to New York, child. I can drive to New York.
It's only like I could drive there too. It's like an hour and 15-minute flight. But yeah. You say you'll see us around the YouTube halls. Yes. Do you have anything that you are doing today, Really B? Please let the people know so that they can find you.
So you can find me at Really B TV. Mm-hmm. That is where I am. We do almost daily hot topics news. I'll be live today at 6:30. And we do we do TV show reviews, you know, mostly these reality shows, situationships, child. I got a good one today for y'all. I'm going off today. I'm telling y'all now, I'm gonna be in rare form. I'm going off today because I got a good one for y'all. I got a good one.
I wish you would have told me what it was so I could have told the people ahead of time, even though you probably don't want me to, like you did me with this Whitehead defamation.
I'm gonna tell you offline what it is. It's a good one though.
See what I'm saying? But I'm gonna come back. I don't know. It might be tomorrow, but it might be tomorrow. But for those of you guys who've been following me with the Tory Lanez, you know I've been on Jose Baez's head about this type of representation. I was talking to Really B, and she didn't know this, and perhaps you guys don't know, but Jose Baez also originally represented Harvey Weinstein, and Harvey Weinstein ended up firing him and asking for his money back. So he's in litigation right now for that. So we might go over that. It's actually a pretty...
Pam, look what Ray said. Look what Ray Bishop wrote in the chat.
You know what? Everybody come in with Pam said, oh my gosh.
Listen, Pam said t-shirts in the court, he will lose it.
You know what? That might, Ray, you own to something right there.
That's a good
t-shirt. I like your marketing mind. I like
that's a good merch t-shirt though. That is a good merch.
I might have to do that. Okay, Ray. I like that, Ray. Thank you. I'm still in that. Don't be trying to talk about you came up with it and all of that. Don't do that, okay?
Just send you a free one. Just send you one for free since you
right. I said it was inspired by Ray Bishop.
Right.
Yeah, we got to get this merch together. But anyway, y'all, thank you guys for hanging out. We'll be back. We'll holler at you next time.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of complice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting.